Getting into the various market-based incentives employed by governments and nonprofits, we must first understand what a conservation actually does. We hear people talk about property rights all the time, but what does that really mean? Property rights have been compared to a bundle of sticks. For instance, a landowner has the ability to sell their property, to use it to grow crops on, to lease the land to another farmer, to sell their mineral rights, to sell their water rights, to subdivide their property, and to develop their property within the confines of the law. A conservation easement deals with and restricts only the last two rights, the ability to subdivide land and the ability to develop land. When a conservation easement is placed on the property, the landowner retains all the other rights of ownership, save for the ability to subdivide and develop. Conservation easements have been codified into state law here in Delaware with the following attached conditions. First, a conservation easement is always a voluntary act or agreement on the part of the landowner, meaning that the government can never force a landowner to place a conservation easement on their property. Second, a conservation easement is legally binding, meaning that if the landowner violates the terms of the said easement, they can be taken to court and forced to comply. Third, a conservation easement is for perpetuity, meaning that the easement runs with the land even if the property is sold or changes hands. And finally, a conservation easement is held by a qualified third party, such as a land trust or government agency, which retains the right to inspect and monitor the property to enforce the terms of the said easement. In 1991, the Delaware General Assembly created the Delaware Agricultural Lands Preservation Foundation for the purpose of purchasing conservation easements on Delaware farmland. Since that time, the foundation has purchased easements on 110,954 acres of farmland, or nearly 20% of the remaining farmland in the state. More than $138 million in state funds have been used to leverage over $46 million from the Federal Farm and Ranch Lands Protection Program and just over $11 million in county matching funds. Initially, the program was funded on a year-to-year basis using leftover cheat funds, but in 2005, the General Assembly passed a law to dedicate $10 million per year from the state realty transfer tax to farmland preservation. In Delaware, a landowner must first apply to place their land in a designated agricultural district before they are permitted to apply for the state to purchase a conservation easement. Agricultural districts are created for 10-year terms, whereby the landowner agrees not to develop their property in said time period. In exchange, the landowner receives property tax breaks and protection from agricultural nuisance lawsuits. The purpose of placing the land in an agricultural district is to first stabilize the land base and allow the state to come up with the funding to purchase the easement over time. Second, after review, the Board of Trustees of the Delaware Agricultural Lands Preservation Foundation votes to create an agricultural preservation district or expand an existing district if the said property is immediately adjacent to one. You can see highlighted in orange the existing agricultural preservation districts in Kent County. Those properties highlighted in dark blue have been protected by a purchased easement through the Delaware Agricultural Lands Preservation Foundation. Next, when the landowner decides they finally wish to apply for the state to purchase an easement on their property, the landowner will pay for at least one appraisal on their farm. The appraisal will determine the value of the potential conservation easement by subtracting the agricultural use value of the farm from the full market value of the property if it were to be sold for development. The easement application process through the Delaware Agricultural Lands Preservation Foundation is a competitive process, meaning that it provides an incentive for landowners to discount or accept less than what the easement is really worth. Thus, an easement on a potential 100-acre property, as determined by the appraisal process, may be worth $500,000 or $5,000 per acre, but to be competitive, the landowner submits a bid for $300,000 at $3,000 per acre. This process is known as a bargain sale, and it allows the state to protect the most farmland at the lowest price with the limited funding available. In return for submitting a bid at a discounted rate, the landowner is able to take advantage of generous federal income tax credits. Lastly, the Board of Trustees of the Delaware Agricultural Lands Preservation Foundation will decide to accept or not accept a landowner's bid based upon the amount of the discount, the per acre asking price, and the availability of funds. In addition, The counties have the role and ability to select properties for consideration if they choose to provide matching funds. If the landowner's bid is accepted, a perpetual conservation easement is placed on the property and development rights are forever extinguished. To give you an idea as to how this process would play out in reality, we start with a 100-acre farm highlighted here in orange. In this fictionalized case, an appraisal determines the full market value of the property to be worth $1 million if it were to be sold for development, while it values the property for farming at $400,000. If you subtract the agricultural use value from the full market value, you receive the potential value of the conservation easement, in this case $600,000. Because the Delaware Agricultural Lands Preservation Foundation operates under a competitive bidding system, the landowner typically submits a discounted bid for a fraction of the value of the conservation easement. In this case, the landowner submits a bid for $400,000. The difference between the value of the conservation easement and the submitted bid is known as a bargain sale, which in this case is $200,000. In this example, once you subtract for capital gains taxes at 15% to cover the lump sum payment of $400,000, the landowner is able to claim up to $155,000 in federal income tax credits over a 6-year period. Combining the lump sum payment for the purchase of the easement and the income tax credits that can be claimed over a 6-year period, the landowner could receive a total compensation of $555,000 or $5,550 per acre. It should be noted that the $155,000 figure is the maximum amount the landowner could receive in tax credits, but depending on their tax bracket and level of taxable income, they may not be able to claim the full amount of the credit. Landowners are strongly encouraged to seek professional legal and financial advice from their attorney and tax professional before going through this process.